Te encargo la grabación también. Hello, good morning, everyone. Following up UNAM Chicago and UNAM Law School webinar series, we're eager to learn about today's topic, which is general aspects of the legal practice in the US. For that matter, I will introduce our speaker who works at one of the most important universities in the US. Justin Swinsick is Senior Director of Graduate Programs at the University of Chicago Law School, overseeing admissions and administration of the Master of Laws, LLM, and Doctor of Judicial Science, GSD. Prior to joining University of Chicago Law School, Justin was the Director of Graduate Admissions at Georgetown University Law Center in Washington, D.C., and Executive Director of International Programs at IE Law School in Madrid, Spain. Justin received a Juris Doctor from Michigan State University College of Law and a Bachelor of Arts in Anthropology from Kalamazoo College. More recently, Mr. Swinsick received a group of students for the International Visit Program for Lawyers last summer in July. He talked about academic opportunities for international students in Chicago and gave them a proper tour of the law school facilities of University of Chicago. Mr. Swinsick has been a wonderful ally for UNAM Chicago and now for its law school. Please note that I will open a question and answers space after the lecture, but feel free to write down in the comments any question you may have. Without further introduction, please welcome today's lecturer, Justin Swinsick.
Thank you so much, Marco. I really, really appreciate it. And thank you to everybody for joining us this morning. As Marco said, my name is Justin Swinsick. I'm the Senior Director of Graduate Programs here at the law school. So I work primarily with all of our internationally trained students, so mostly our LLM and JSD students. So it's lovely to be in touch with you. Most of my work is done with internationally trained lawyers, and I had the opportunity to actually visit UNAM about 6 or 7 years ago. So I think it's about time that I make it back down there. A little bit long to go in between visits down there. So it's a real pleasure to be working with all of you, to be here with you this morning. So the idea with this, and when Marco reached out to me, is to kind of give everybody just a very broad general view of some aspects of US legal practice. And I know that you're hearing from some other people at different universities. So I hope that this fits in well with the overall picture that you're gaining. And so my idea today is to just briefly talk a bit about kind of legal education in the United States, how one becomes a lawyer, kind of what that structure looks like in the United States. And then I'm going to talk a little bit about civil procedure and kind of the structure, the very broad structure of the court system in the United States and where cases are heard. And again, this is going to be kind of like a 1,000-foot view of everything. There's going to be lots of exceptions to the things that I'm saying, but I'm just trying to paint a very broad picture of these aspects so that you have a general idea of how things work here in the United States. And as Marco said, I'm more than happy to take questions. So definitely, please do share your thoughts and your questions that you have for me. So just to get things started, some of this may be familiar for you, but legal education in the United States is only offered as a graduate level degree. We don't have a first degree in law in the United States at the undergraduate level. So like at UNAM, you guys are all studying to become abogados from your university. We don't do that in the United States. Rather, we only offer law at specialized institutions that offer legal education. And so in the United States, we have 199 schools that are approved by the American Bar Association that offer legal education that will allow somebody to get the credentials that they need to become a lawyer in the United States. And kind of when I talk about this, I always get a lot of questions about the American Bar Association and what they do. And it's important to remember The American Bar Association does not oversee the actual practice of law in the United States. Rather, that is left to each individual state itself. The American Bar Association instead focuses on one being the institution that oversees kind of law schools in general in the United States and establishing the parameters under which they will be operating, how they should function, and kind of setting minimum standards for the law schools in the United States. And they also draft a number of model rules and model practices in a variety of different areas. So they're kind of a single point of reference for a lot of different areas, but they do not control the practice of law in the United States. So when somebody says that they're a member of the ABA, that just means they paid some dues to the ABA and they get free information from the ABA. But for our purposes, the ABA primarily works with law schools in kind of establishing the structure for the main programs that law schools offer in the United States. And the top number one program and the real reason for the existence for law schools in the United States is the Juris Doctor, the JD. That is our first degree in law and is the degree in law that most people will seek when they're looking to become a lawyer in the United States. So the JD, the Juris Doctor degree, is typically going to be 3 years on top of the undergraduate education that you've already studied. So for example, I studied anthropology in my undergraduate education, and then I went on to a specialized law school and I got my Juris Doctor. And that's what made me eligible to sit for, I eventually took the New York bar. So that's the most typical. Then we also do have LLM programs, Master of Laws programs, that are designed primarily for foreign trained students that want to come to the United States and get a 1-year experience studying something, focusing on US legal practice, US law, maybe a specialization. But also the Master of Laws does create a pathway for students to be able to come into the United States and be licensed to practice in individual states, because individual states do not discriminate based on national origin or citizenship when it comes to becoming a qualified lawyer in that state. They're completely separate rules that govern that, and citizenship and national origin is not one of them. But it's also important to remember that what the experience of studying law in the United States is like, because it's a rather unique experience, and I think it's worth mentioning, because we often talk about the experience in US law schools as learning to think like a lawyer, or in the case of our students coming for the LLM, it's learning to think like a US lawyer. So the experience really focuses a lot on advocacy, reasoning, analysis, logic, discussion and debate, and this Socratic method where there's give and take, discussion and debate between faculty, students, and the students themselves. And the majority of the law that you're learning when you're in law school in the United States is done through judicial opinions, cases. Now, we have statutes in the United States. We have lots of statutes. I think that's a big misconception about the common law and its practice in the United States, that everything is purely judge-made. While it's true that the interpretation of law and new rules come out of that, there are a lot of statutes as well. However, when we are studying law in the United States, we're not simply reading the statutes. We're reading how they've been interpreted and applied by judges, and how those opinions and those decisions are going to be applied again in future cases. So you're going to be discussing and debating the differences in facts from one case to another, how a law should be applied from one case to another, and using the opinions of judges to support your arguments. So there's a lot of active participation, a lot of back and forth with professors. And so faculty take that responsibility very seriously, and they tend to have a very close relationship with students in law schools. Now, most law schools, in spite of what you see on TV and in movies, don't focus a lot on oral advocacy. They're much more focused on writing skills for lawyers, and this is reflective in the type of exams that students take. So most classes in US law schools are going to focus on your ability to write, your ability to defend a position, to make an argument with your writing skills. So your exams are typically going to be written. You may have some paper exams or some papers due in different classes, but most of your classes are going to have written examinations where you have a closed amount of time to defend a position, to defend a client that's in a really bad spot, and use all of the tools that you have from studying in a particular class, all of the judicial opinions that you've studied, the particular statutes, and to craft and advocate for a position based on that material. Two other things that are relatively unique to US law schools are clinics. So in US law schools, there's a large focus on getting practice before you actually leave. And this is typically done through the clinics. And so clinics are run by faculty at the law school working on real cases so that students have the opportunity to go out and actually practice what they're learning in the program. So it's a big part of the experience at law schools to be US law schools to be involved in clinics. We also have moot court. In spite of what I said earlier, that we don't focus solely on oral advocacy, there are opportunities to improve oral advocacy, and this is typically done through a moot court or mock trial where you have a fake case and you go before fake judges and argue your case. So to become a lawyer in the United States, there are a number of different steps that you have to take along the way. Obviously, the first one is you have to complete your legal education. And depending on the individual states, that's going to look a little bit different in every state. I always give California as kind of the most extreme example because most US states will require that you have graduated from an ABA-approved law school. However, in California, they have their own approval system. And so you can have graduated from a California law school that may not necessarily be ABA approved and still gain access to legal profession in the state of California. And over the years, the way that people have accessed legal practice in the United States has changed dramatically. So this is something that's always kind of morphing and changing and developing. I mean, at one point, all you had to do was read the law. You simply worked with a lawyer and worked with them and read the law under their tutelage, and then you could become a lawyer. So it's constantly changing, but currently most states are going to require that you have graduated from an ABA approved law school. Then you're going to have to apply for, sit, and pass their state bar exam. Most bar exams are going to be 2 days. They're going to focus 1 day on issues that are called multi-state. These are more general topics focusing on common law practice throughout the United States. And then the second day is going to focus more on very state-specific law, because you can only practice in a particular state if you're licensed in that state. So if, for example, I'm licensed in the state of New York, I cannot go to California or Florida or even Illinois where I live and hold myself out as a lawyer and practice law in those states. I could only do that in New York. So if you wanted to practice in multiple states, you would need to pass the state bar exams in all of those states, because we do not have a single federal jurisdiction that controls the practice of law throughout the United States. Now, some other steps that usually get overlooked until you're actually going through the process is that you also have to pass a professional responsibility exam that's wholly separate from the state bar exam and is going to focus on your knowledge of ethics and professional responsibility rules as a lawyer. You'll also have to pass a character and fitness test. So this is going to be a fairly deep background check into you, anything you may or may not have done, and then show that you can uphold the standards of a lawyer within that particular state. I still can remember very vividly having to sit before a judge in New York and have them go through all of my paperwork and ask about my backgrounds. As you would imagine, they want to make a little bit of money. You're going to have to pay some state dues. And so most states will have a requirement that either every year or every other year, you have to pay dues to keep those up. For example, in New York, every 2 years, I have to send them a check to remain a licensed attorney in the state of New York. There may be other requirements depending on each individual state. There may be a requirement of pro bono hours that you have to complete before you can be admitted to the state bar exam, or you may have a minimum number of hours per year that you have to maintain. You may also have to perform continuing legal education credits so that you can show that you're keeping up with current trends in law. Most states do have a certain requirement of courses that you have to complete during the year to be able to maintain your license in that state. Now, if you're interested in kind of diving a little bit deeper into individual states and what their requirements are, I recommend going to this website, ncbex.org. They do a really good job of kind of presenting every state's different rules and requirements. Now, you'll need to go to the individual state to get the real deep dive, but NCBEX does a really good job of giving the overview. And they're actually the organization that puts together the MPRE, the Professional Responsibility Exam. So as I've mentioned a number of times, practicing law in the United States means that you're only eligible to practice within the jurisdiction that you're authorized. So again, New York for New York, California for California, Florida for Florida. So that goes for each individual state, but it also functions at the federal level. And so you need to be authorized before a federal court to be able to take a case for a client in that particular federal court. Now, usually this is going to just be some paperwork. It's not terribly onerous, but you still do have to be authorized, and you still do have to go through a process to be authorized by that court to try a case. Now, the question that I get the most is, so what happens if you're a practicing attorney in New York and you have a client that has a case going on down in Florida? What do you do? Well, one, you could refer the case to another lawyer in that other state. But if that's not really an option, you can also go to the courts in that other state and ask for permission to practice law in that state for just that case and for that client. And that is called pro hoc vice. US lawyers, we all love Latin terms here. This is just a great example of it. But this is what you would request from a court in a state where you're not authorized. So they give you kind of that free pass to be able to defend your client for that one particular case. Now, with the practice of law in the United States, a lot of this is going to depend on the structure of our government in the United States. And so I think it's worthwhile for us to kind of take a step back and take a look at the structure of our government and take a look at how we have organized jurisdiction throughout the United States. So we call that our civil procedure, and that's one of the main courses that US law students take when they're in a US law school. So at its most basic, the most fundamental structure of our government is two broad levels here. So we have the federal level, the US level that's created by the US Constitution, which creates the three different branches of our government and creates the separation of powers that we have. So the kind of the structure that I have here on the slide is you're seeing that at the horizontal level is where we have the dynamic of separation of powers, so that each portion has their own power and their own kind of their silo. And then we also have a vertical relationship, because we have the federal level that's created by the US Constitution, and then we have the state level as well. So the 50 different US states, each one with their own constitution, their own structure, creating their own legislative branch, executive branch, and judicial branch. So the real question for us here, and what we're going to talk about, is kind of that relationship vertically between the federal level and the state level, that vertical dynamic here. So I think this map does a good job of kind of demonstrating to you the level of complexity that we have in the United States when it comes to jurisdictions and the structure of kind of our court system in the United States. And so what I'm showing you here is just at the federal level. This doesn't show what we have at the state level, because obviously each individual state is going to have power and sovereignty within its borders, but even within those borders, it breaks down even further between different counties, townships, cities. There are all kinds of different court structures that we have. So it's an unbelievably complicated system. But I'm going to talk a little bit about the federal system and the federal structure that we have here. So what you're seeing here is the distribution of our courts of appeals and our U.S. district courts. So the district courts are going to be, it's kind of hard, and I'm not sure if I can get if you can see my cursor on here, you'll see kind of these dotted lines going through the particular states, because some states are split up into smaller districts based on population. Where you don't see any lines, that means that state is a district in and of itself. So it would only have one court, one district court within that particular state, because each district is going to have a particular district court. And we have 94 of those district courts throughout the United States. And so that is the base level of our federal court system. That's the trial level. So if you have a case that's going to the federal level, that's where it would start in most cases. Then the next level up from that is the Court of Appeals. And for that, we break up the country into different circuits. And so we have 13 different circuits. We have the 11 circuits that are shown on here, plus a circuit within the District of Columbia, and then a separate federal circuit that only hears very specific types of cases, kind of in very specific areas: patents, immigration, trademark, so things that are very, very specific to federal law and the federal government. And so now when you have a case at the district level, if you want to appeal, you would have to appeal to the level within your circuit, the circuit that corresponds to your particular case. And that circuit is going to cover that entire geographic area. So the Ninth Circuit covers the entire West Coast, including Alaska, and Guam and Hawaii, going all the way out. The first district over on the East Coast is going to cover these the New England states plus Puerto Rico as well. So they're much broader in scope, and there's only one appeals court in each of these circuits. Then the next level after that is, of course, the U.S. Supreme Court. So civil procedure, kind of how do we create the rules that decide which court is going to hear a particular case? So there are three ways that procedural rules are created in the United States. So we have constitutionally. So the Constitution establishes that the Supreme Court has jurisdiction over federal questions of the Constitution. Then we also have statutes, and that's where the majority of our procedural rules come from. So at the federal level, we have the federal rules of civil procedure. At the state level, every state is going to have its own procedural rules. Most courts are going to have their own procedural rules. So most of our procedural rules do come from statutes. But they can also be developed through the common law and through cases. So things like, you may have heard of the Erie Doctrine, for example. That came out of a case that was looking at a particular aspect of procedural rules, and it made a determination, and that rule that came out of that case out of Erie is applied in future cases. So common law is the third way that we have it. So we obviously have the 50 state rules plus the federal rules. And then in the broadest scope, in what we're going to look at here is kind of the distinction between federal and state jurisdiction. Because if we went any deeper than that, we'd be here for about 200 hours. And I don't think anybody wants that. So I'm going to talk first about kind of our concept of jurisdiction in the United States and kind of how we approach things, because the history of the United States has a lot to do with how we structure ourselves and how we actually look at jurisdiction. The first of which is the concept of territoriality. And this is really born out of the kind of the start of our country, from when we were just 13 colonies, and trying to determine whether or not we should actually be a union or whether or not we should be 13 individual states, countries that govern themselves. So this idea that each state is a separate sovereign and a separate entity and is sovereign over the residents and domiciliaries of its territory is still very much a part of kind of who we are and how many people think, and is very much a debate that is still raging today. There's deep discussions over whether or not states should have more rights, should be stronger, or whether the federal government and Congress, US Congress, should have a greater say in the rules that govern day-to-day life. And so our concept of jurisdiction was really born out of that. And then the second kind of broad concept that we look at in our jurisdiction is this idea of consent. Whether or not you consented to have a court in a particular place make a judgment that's going to have an effect on your life, your liberty, your freedom. So how do we establish jurisdiction within a particular court? And we're going to talk really broadly here about federal versus state. And even more specifically than that, we're only going to talk about how a case goes at the federal level, because that's the simplest. And if it doesn't go to the federal level, then it goes to the state level. So we're just going to break it up into these two broad categories. And there are three areas that we need to discuss to find out whether or not a federal court can actually have jurisdiction over the case. And the first is subject matter jurisdiction. The second is personal jurisdiction. And the last is venue. So the first one we're going to take a look at, subject matter jurisdiction, the definition of which I give you right there. So subject matter jurisdiction is the actual power of a court to hear and determine cases of a general class to which the proceedings in question belong. So what does that mean in plain English? What that means is that it tells us generally what courts can hear a particular case. So in our case right here, federal versus state court. But it could also be something more specific, like tax or a family court or a small claims court or a patent, something very specific. That subject matter has to go to a particular court. So in the case of a federal court, we need to have one of two things to be able to bring the case before the federal court. So one is either a federal question, and that's known as federal question jurisdiction. So where there is a case brought by a plaintiff, and on the face of the case, there is a federal question at issue that is the crux of the case, then that case will go before a federal court. And this is constitutionally and statutorily granted. So Article 3 of the Constitution establishes that the US Supreme Court has jurisdiction over federal matters. And then Congress has passed legislation that grants all lower federal courts jurisdiction as well over federal questions. And so this is not discretionary, that where a plaintiff brings a case based on a federal question, that before a federal court, then the federal court has to take the case, and they're not going to kick it down to a state court. The other way to establish jurisdiction in a federal court is through what's known as diversity jurisdiction. And when we're talking about diversity here, we're not talking about diversity in terms of race or gender. We're talking about diversity in where the parties themselves are from, where they're residents or where they're domiciled. Your domicile is the permanent place where you live. So to have a case go before a federal court that's based on diversity first of all, you have to have what's known as complete diversity. Both of the parties have to be from completely different places. They cannot be from the same place. You could not base a case on diversity with two people from Ohio, for example. They would have to be from New York and Ohio. And there cannot be like a substantial connection with the other state, which would destroy the diversity. This gets really complex when you have multiple parties as well, because if you have one party on one side that's from Ohio, another party on the other from New York, but the party from New York brings in a third party from Ohio, then you no longer have complete diversity, because everybody on both sides of the case have to be from different states. And without that, you cannot have complete diversity. And if you don't have complete diversity, the federal court is going to kick it down to a state court. You also have a minimum requirement for the amount that's in question here. So you have to have a case that is over a controversy where at least $75,001. So it has to be more than $75,000 is concerned. If it's exactly $75,000 or less, the federal court is not going to hear it unless, of course, there's a federal question involved. And this is granted by a federal statute, and again, is not discretionary. If a party brings diversity and there's complete diversity and all of the other requirements are met, then that case will be heard before a federal court. Now, the next level of analysis that we have to have is personal jurisdiction, whether or not a court actually has jurisdiction over an individual defendant. And now I mentioned specifically here defendant, because we don't have to worry about personal jurisdiction for plaintiffs, because the plaintiff is the party that's actually bringing the case. And if they have already gone and brought a case to a particular court, they have done what we call availed themselves of personal jurisdiction. They've said that, yes, I will abide by what this court says, and I want this case heard before that court. However, the defendant never had that chance to make that decision, because they're being they're being forced into a particular court. And so the court needs to be certain that there are certain contacts with that jurisdiction in that court, so that they could render an enforceable judgment against that defendant. Because again, like I talked about before, this idea of consent in being hauled into a court that you never consented to is very much a part of our history and the United States. So for example, let's say my wife decides to divorce me. We live in the state of Illinois, and then she moves up to the state of Alaska, but she decides to file for a divorce in the state of Alaska. I have no connections with the state of Alaska. There's nothing up there that ties me to it. I haven't consented it. My wife moved up there. She decided to go there. So it's unlikely that a court in Alaska would find personal jurisdiction over me. Let's hope my wife doesn't decide to do that, but you get the idea in the hypothetical. Now, there are a few different concerns here that we need to keep in mind with personal jurisdiction. Obviously, the distant forum concern with my example of Alaska. And so we overcome this by allowing states states to have jurisdiction over all its residents, the domiciliaries, or people with minimum contacts. So people that have done something to connect themselves with that particular jurisdiction. They've moved there, they've done business there, they've traveled there very specifically related to the case at hand. There's something. Now, there's a whole huge set of case law on this, so we won't go too deeply into it. But to establish that personal jurisdiction, you would have to have one of those things, minimum contacts, domiciliary, or it be a resident. There's also a big notice concern because you want to make sure that people that are being hauled into court have been actually noticed and notified that the case is being brought against them, so that they have ample opportunity to defend themselves. Because unless they're notified, they can't actually come to court, bring a lawyer, defend their position. So there's always going to be this notice concern with personal jurisdiction. So if there isn't proper notice to the defendant, then you might lack personal jurisdiction. And then finally, this is something that's actually ensconced within the US Constitution in the Due Process Clause of the 14th Amendment, which states that no state shall deprive any person of life, liberty, or property without due process of law. So you have to demonstrate that you have provided specific due process. Now, what that means is a really, really deep question, but just know that this is one of the main elements under personal jurisdiction as well. Now, finally, just really briefly, I want to distinguish between personal jurisdiction and venue. So personal jurisdiction simply establishes the ability of a court to be able to render a judgment enforceable against a defendant, whereas venue is the question of whether or not a specific court in a specific place is the actual right court to hear a case. Because you may be able to establish personal jurisdiction at a broad level of the court system, but then you have to decide which one of the courts is actually the best one to hear the particular case. So you're going to be looking at things like, where did the actual case take place? Where do the parties live? Where was real property located, if that's something at issue. And so there needs to be a connection with the specific place, as well as the case and the parties themselves. All right, so that's my presentation. I'm happy to take any questions that you guys may have. Can pass them along to you as well. But yeah, I think we're at a good point now where we could ask some questions if you have them.
Thank you so much, Justin, for sharing us this valuable information in regards of the aspects of the professional exercise here in the US for lawyers. So we have some questions, and the first one is, can you tell us what could be the main criteria to establish the difference between one jurisdiction and another, considering that we find in this controversy of ideologies?
Yeah, so the establishing the jurisdiction is, you're gonna need to go through that process that I went through there. So you're gonna have to have the subject matter. It's gonna have to be, if it's a federal question, that's going to the federal level. State questions go to the state level. Now, again, that's really broad because there are circumstances where a state court can hear federal issues and a federal court can hear state issues. So that's really, really broad view, but you definitely need to establish the subject matter for it. Personal jurisdiction, whether or not the court can actually establish or render a judgment against a defendant, and then make sure that it's the right venue. So that's the broadest scope.
Thank you for sharing, Justin. So we have another question from Miguel Angel. How does the US legal system handles students from other countries who underwent bicultural legal system studies in their own countries?
Yeah, so the Master of Laws program is specifically designed to provide students that receive their first degree in law outside of the United States the opportunity to come in, get a view of US legal practice, maybe specialize in something, and perhaps even qualify you for sitting for a New York bar. And so there's going to be a lot of coursework that you are going to take that's going to be kind of the elemental coursework that students in the JD program also take. So it depends on from program to program. Every school does it kind of differently, but my suggestion is always to take some of those fundamental courses, especially things like reading, writing, research, and analysis, which is a course that focuses on how lawyers in the United States actually write, how they structure their writing, how they make arguments, how they approach structuring materials in within their arguments. So I always recommend to students to take those kind of foundational courses, because it really does help bridge the gap between your legal knowledge from your home country and U.S. legal practice.
Thank you so much, Justin. Continue with the questions that we have. In your opinion, what would be like the most challenging aspect for international lawyers when they are pursuing an LLM or maybe a JD here in the US?
Yeah, in my experience, the most difficult thing, well, I'd say there's two. There's two things. One is just keeping up with the reading on a daily basis, and especially reading in English, because there is a huge amount of reading that students have to do. And the type of reading that you do in US law schools is very unique. Reading a judicial opinion from a US judge is very different from reading anything else, because there are specific things that you're looking for. You're looking for what the decision was, what the holding was, so the thing that can be applied to future cases. But then you're also trying to decipher out what is actually applicable to future cases and what is just what we call dictum, things that the judge is just opining on and just giving their 2 cents, their opinion about. So the reading the cases, there's definitely a learning curve there. And then 2, dealing with uncertainty. This is especially true for students that come from civil law backgrounds, like in Mexico, where you have a statute. I mean, it's not always super cut and dry, but you have a statute. You go to the statute, and that's the path that you follow. That's not always the case in the US, and especially in the classroom as well. There's never a right or wrong answer necessarily. There's lots of shades of gray, and the experience in the classroom is much more about defending your position and using the materials that you have to craft an argument. And so kind of getting their heads around that takes some time. So those are the 2 areas where I see LLM students kind of struggle a little bit to catch up.
Yeah, and completely makes sense. You know, the lectures in another language, you know, that could be definitely something challenging for any student at all. So we have another question, Justin. Do you think that the process to become a lawyer here in the US, it's already perfect, or do you think there is some things that you can or can be changed in order to, you know, set better rules for the lawyers? Because in Mexico, for example, you get your admission to practice law once you get your law degree. But here, like you said, and like you explained to us, it's not enough to obtain the JD or the LLM. You gotta sit for a bar exam, which depends on the state that you wanna be admitted to the bar.
Yeah, well, especially having the opportunity to kind of compare and contrast it to a lot of countries. I think it would be useful in the United States to have, and this obviously goes from state to state, to have perhaps a little bit larger requirement on practice and experience before you become an actual licensed attorney. There are many countries where you are just a provisional attorney for the first 3 years, and until you hit a certain mark of experience, you're not provided with your full license. Because in the United States, and once you pass the bar and pass the MPRE, pay your dues, do all of those things, you can go hang out your shingle. That's the phrase we would say, that you can go out and you can be a lawyer and you can defend anybody within that jurisdiction, whether or not you actually know what you're talking about. So I think perhaps a little bit more experience would be helpful.
Yeah, definitely, because you know the area that we practice, we must have experience, and we need not to improvise. And you know, it's a really important aspect of being a lawyer here in the US, having this experience. Continuing with the questions, Justin, the LLM program for international students that University of Chicago is really popular, and is I gotta say is one of the most interesting and one of the best options for international students pursuing an international degree.
Mhm.
Would you encourage our students or community in Mexico for after graduation pursuing this LLM at University of Chicago?
Yes, absolutely. But my more detailed answer would be that, I mean, do your due diligence on it. Think critically about it and how it fits in with your broader goals, kind of where you are and what you want to do, because it's not a small undertaking. It's not a small undertaking financially. As I mean, most U.S. law schools, especially at our level, I mean, we're charging $75,000 per year. And there are scholarship opportunities and there are all kinds of things that can help you. And I'm happy to talk about those later. But it's a big undertaking. So you want to make sure that that investment in yourself is going to pay off the dividends that you're really hoping for and put you in a position to succeed in an area that you want to succeed. So make sure that you're talking to people that have gone through that experience, that have done it, and that they can talk to you about what it was like and whether or not for them it did put them on a path for success and where they want to be, or could they have gained what they wanted without it. Now, I think there are all kinds of huge benefits to it, and I'm happy to talk about all those. But I always tell people that you need to think critically about it before you go into it, because it is a very big investment.
Thank you, Justin.
One other aspect
Yes,
to add to that, I'm sorry.
of course.
I would always say also that if you're only pursuing an LLM because you want to practice in the United States, like fully and get a job here, you're going to need to rethink the reasons for it. Because while it's true that every year a number of students do end up finding full-time employment in the United States, that's the exception, not the rule. Because even with an LLM or even a JD from a top US law school, unless you have the authority to live and work in the United States, employers are hesitant to hire you. So make sure that you're pursuing the program to provide you with success back in Mexico or another jurisdiction or another country.
Yeah, I think that our community deeply appreciate these tips that you are giving to them, because yeah, definitely those are some aspects that anyone should be concerned about before going to these international universities based here in the US. The last question would be, Justin, lawyers here in the US have like a personal record, or there's a website where you can check all the cases that you have like a personal library, you have a
Like a database for
yes for the cases that you've seen.
You can look up, you can check whether or not somebody is licensed in a particular state. So you can go to that state's bar association website and you can look them up by name. Obviously, if it's something very common like John Smith, there's going to be a bunch of them. So you better know something a little more specific about them. But those websites aren't going to contain like the cases that they have. You would have to go to like their law firm's website or any kind of personal website. You can find out whether or not somebody is actually licensed.
Yes, and in regards with the legal cases, with the precedents, you have like a database. Does the state has like a database for all these legal cases that have
No,
been
not the
presented?
individual cases. No.
Oh, okay.
No. I mean, if there was a public case that had the parties listed on the docket, then you could find it that way, and you could look at court records. You could look through Westlaw and LexisNexis if there's a public record of it. But in a lot of instances, there aren't public records necessarily of that.
Yeah, I don't know if you have the numbers, but in your experience, you work close with the international students in your office. Do you have like not the numbers, but like an approximate, like how many graduates pass the bar exam, any bar exam? Or
Oh yeah. So well, we get New York's numbers every year. It's rare we have a student that takes another bar exam. Like every once in a while, we might have somebody that takes California. But usually it's everybody is taking the New York bar. And on average, we're at around 75% pass rates for our students, which is well above the normal rate for New York, which is like covers like at around 35 or 40%, something like that.
Well, thank you so much, Justin. I believe that this information is really valuable for the community, and we deeply appreciate your time, your participation, and thank you for being such a marvelous ally for UNAM Chicago and UNAM Law School.
My
Thank
pleasure.
you so much again, Justin.
No,
And
wonderful having the opportunity, and I hope to get down there soon.
of course, we will make the arrangements to get you there. And for all the audience, thank you so much for being here. Tomorrow will be the last day of this webinar series that we're having with Professor Manuel González Oropesa from the law school from UNAM. That would be the last lecture, and it would be about the differences between common law and civil law that we have in Mexico, and the common law which we have here in the US. Thank you so much for being here, and we'll see you tomorrow. Thank you again. See you, Justin.
Take care, everybody.